Farmers across Louisiana, locked in a more than 14-year fight with railroad companies over the closure of private railroad crossings, have cause to celebrate. The Louisiana Supreme Court handed down a decision in June that prevents railroad companies from closing private crossings without approval of the Louisiana Public Service Commission. In a June 30th opinion by Justice Jeff Hughes, the court found that Union Pacific Railroad's constitutional challenge of a 2008 law that required proposed railroad crossings closures be approved by the Louisiana Public Service Commission was, in fact, constitutional. The case, which pitted farmers and private landowners against Union Pacific Railroad Company, raised several legal issues, including whether the railroad had the exclusive legal right to close private rail crossings, and if so, if the railroad owned the land under the crossings. The High Court ruled that the railroad could not close a private rail crossing at its discretion without having to provide sufficient notice so that interested parties have an opportunity to be heard at a public hearing. However, the court opined that closure is automatic only if, after a public hearing, the railroad can establish that the private railroad crossing unreasonably burdens or substantially interferes with rail transportation. This ruling effectively ends a nearly 15-year legal battle between farmers and Union Pacific, which closed nearly a dozen private crossings without public hearings before the LPSC back in 2006. In August of 2008, the Louisiana legislature passed revised statute 48394. The law requires a railroad company that wants to close a private crossing must submit advanced written notice to the Louisiana Public Service Commission and to the owners of record of the private crossing traversed by the rail line.